Yo, 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 it's JP. Today's lesson is on defamation law. This one is for all my friends out there in corporate America. So the latest trend involves big companies and their big corporate law firms sending me a cease and desist letter because I post something on LinkedIn where I talk about a company and I talk about corporate greed, corruption, malfeasance, sexual harassment, sexual assault. I tell a story about something that happened in one of the cases or matters that I'm working on. And I talk about the corporation engaging in all sorts of shenanigans. And I talk about their go-to strategy, which involves hiring a big corporate law firm and typically hiring one of these big shot corporate bully ball lawyers who I refer to as, Voldemort, Skeletor, what, right? They hire somebody who is like a cartoonish bad guy who comes in and just threatens to destroy you and burn you down and says, govern yourself accordingly, et cetera, et cetera. And this is just this is like a fact pattern. This happens so often that it is a thing. I will post a story. I won't name a company. I won't name the firm that's involved. I won't provide any identifying details. I'll just say, I'm working on this wild case or wild situation. Here's what happened. Here's my commentary on it. And then I'll just, make fun of some of the folks involved because they're ridiculous. And so I get emails, right, with a PDF attached. That's always how they do it. They put a letter on letterhead, and the letter says, we have discovered your LinkedIn post dated XYZ, and we suspect that your post is about us. And we find your post highly shocking and offensive and unfair and inappropriate, and we believe this is defamatory. And we reserve all rights. And we respectfully request, or we demand, that you take it down. Well, gee golly, okay. Let's unpack this, friendo, all right? So defamation requires that the publication either A, identify you, or B, provide such details about you that the reasonable person would know the statement or speech is about you. That is black letter law. Black letter law, right? So I understand that I live rent-free in the heads of so many people in corporate America and big law. And so they have nightmares about me, and they think that I have a target on them and I'm going after them, or that they're on the top of my list, right? Like, there are hundreds and thousands of you big corrupt companies and corrupt corporate lawyers, right? Like, you are not special to me, okay? The fact that I might have a particular case or matter or controversy with you, that doesn't mean that you are the center of my worldview and universe. I'm not obsessed with you. Again, there are thousands of you engaged in similar shenanigans. That's why, in the most supreme irony, there have been instances where I post something on LinkedIn where I talk about various corporate shenanigans, and I get one of these cease and desist letters where the company and their lawyers say, we suspect that this post is about us, and we demand you take it down. It's not even about you. It's not even about you. How deeply in people's heads and how much control of your psychology do I have if I am posting about X and you show up and say, I'm Y and you're talking about me? Okay. Mind-blowing. Trolling the world. Mind-blowing. But back to the law. Okay? Back to the law. If you're going to threaten me with a lawsuit, defamation, this, that, and the other, one, in the vast majority of those instances, that's just naked bad faith. That's naked bad faith. You and your client got angry, your client holds the purse strings, your client says, damn it, we need to do something. We need to do something about this. And so you have to resist that urge, right? In any kind of conflict resolution, conflict escalation, disputes, altercations, whatever, You have to resist the urge to just do something, right? You have to resist the urge to just do something. Because a lot of times that itch, that need, that insecurity, that's from insecurity. That's from insecurity. That's fear. That's fear, right? You're afraid. And so you're over there saying, I have to do something. I have to do something. I have to do something. Pollard said something. We're offended. We're upset. We have to do something. And so when you send me a cease and desist letter, where you say, oh, this is shocking and offensive and unprofessional and defamation. No, it's not defamation. The fact that you might be shocked and offended and outraged by something that I say does not mean it is A, defamation, B, otherwise actionable, or C, a violation of any professional obligations. I will die on this hill, people. I have been standing on this hill for the last 12 plus years. I will die on this hill. We can have this fight, okay? We can have this fight. I am a lawyer, but I'm also a writer. I am a public intellectual. I'm a public figure. I have a following of 80-some thousand followers online. People listen to what I have to say for a reason. I am a voice that people connect with. People think I make a lot of sense, and the public has a right to know all of this. The old guard model of law, the establishment, the power structure thrives in secrecy, and they demand secrecy. They demand secrecy. Why? They don't want sunlight. Because as Justice Brandeis once said, sunlight is the best disinfectant. So all these people want to do a bunch of dirty shenanigans in the dark, and they want you to sign a damn NDA. They want you to sign a damn NDA. Do you know how many times we get into litigation with these companies, and at the end of the case, they want to settle, tap, 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 and then what do they say to me? They say, we need Pollard to sign something saying he's not going to talk about us, or we need Pollard to sign something saying he's never going to make a public statement about the case. Not how it works, hombre. Not how it works. Not how it works. You can't put a restriction on me and say I can't talk about you or about my cases against you, because what if a client reaches out to me? In fact, what if it's a sexual assault case, okay, against a big retail company, and we do the case, and I know for a fact there are other victims out there. There are other people out there who have gone through the same ordeal. They've got the perp or the bad actor still employed at the company. You're not going to shut me up. You're not going to shut me up because these people have a right to counsel. These people have a right to counsel. And what you're really trying to do is you're trying to prevent these people from finding me, and you're trying to prevent me from speaking out, educating these people about their rights, giving these people strength and encouragement to come forward and do what? Vindicate their rights. Silence is all about preventing people from knowing their rights, having knowledge. Knowledge is power, and preventing people from ultimately vindicating their rights. I don't play that. I don't play that. Just because I'm a lawyer doesn't mean I sacrifice being everything else. Just because I'm a lawyer doesn't mean I can no longer write, speak, educate, advocate, publish, okay? The rules about what lawyers can say, right? Everybody's all confused on this. Lawyers are so confused about this. And I don't even know if it's confused. I think it's intentional. Like, there's this whole line of argument and narrative about, oh, lawyers can never say anything about cases, right? Oh, you can never say anything about cases, right? That's just the secrecy. That's the secrecy model. That's the secrecy interest. That's the keep it all under wraps, keep it all in darkness, keep it all in silence. Because big, powerful, corrupt corporate actors, big, powerful, corrupt corporate law firms, they thrive if they can keep the people at large in the dark, uneducated, ignorant, unaware of their rights, prevent these people from identifying and accessing sophisticated counsel who are not afraid of them. And they expect everyone to be afraid of them, right? But in terms of what lawyers can say or cannot say, the real rule about speech implicates pretrial publicity, right? There are rules against unfair pretrial publicity. And then you collapse back. Okay, there are bar rules where it's like, oh, you can't say stuff that's unbecoming of the profession. A lot of those rules are unconstitutional. A lot of those rules are utterly unconstitutional. If I'm speaking, okay, and I'm not speaking in a court, in a pleading, in an email with opposing counsel, and I'm speaking to the public at large in a public forum, I have pretty broad latitude to say a whole bunch of different things. And if I think somebody is engaged in conduct that is shenanigans, or I think somebody's using heavy-handed bully tactics that are ridiculous, or I think somebody's acting like Voldemort and they're playing the Voldemort card, I'm allowed to say that. I'm allowed to say that. That's not a violation of any professional ethical rules, and that's also not defamatory or otherwise actionable. So you either don't know the law, or more likely, you are simply acting in bad faith and just making these bad faith threats, because it goes back to, you got to do something. We got to do something. We got to do something. We got to do something. And that's a tell. That's a tell. Okay. Whenever you're in any kind of scenario like this, conflict, altercation, whatever, like when you force the other side's hand and they get nervous and they have to do something, but the something they do is a weak play, that's a tell. It shows you're shook, right? And it shows you're spooked. It shows you're terrified. It's a tell. You're showing your hand. Get better at poker, okay? Get better at poker. So it's not defamatory, actionable, etc., okay? But let's talk about what it is. Let's talk about what it is. The Streisand effect. The Streisand effect. What's so interesting about hubris is that if you study, if you watch, if you observe, if you listen, if you read, okay? If you are an educated person sort of in the ways and machinations of modern society and the trends and the scenarios that play themselves out over and over again, you would already know what this is. This is a Streisand effect, okay? Barbra Streisand had a house in Malibu on the coast, and there had been a study and a series of photographs taken about the California coastline and erosion. And wouldn't you know it, there was a picture of Barbra Streisand's mansion in that particular study or catalog of photos, and it was available online. And Barbra Streisand and her people found out about this. You could read about it. Look up the Streisand effect, okay? But they found out about this. And Barbra Streisand, she lost her shit. And she was like, her lawyers sent a letter and was like, we demand you take that down and you take her name off of that and blah, 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 blah. And we will sue you and you are so sued and govern yourself accordingly. You know how they do. You know how they do. And so the situation blew up and it became a huge public spectacle. And then hundreds of thousands of people started looking at this picture of Barbra Streisand's house. And it became this massive media firestorm, and it drew all this focus and attention. Do you realize that before Barbra Streisand had her lawyers go on the warpath, less than like 10 people had ever looked at this picture, right? So like nobody cared, okay? Maybe it was out there, but nobody cared. Nobody really cared, not to any massive degree. And then Barbra Streisand like kicked up a hornet's nest and it became this big public spectacle. That's a Streisand effect. That's a Streisand effect. There's a Chinese scholar or philosopher. I don't know how to say it or what it is, but there's a term for it in Chinese. If you go way back, it's like right. It's that exact scenario where it's like, there's this thing, nobody's conscious of it, and you magnify it, and then, right? And that's the Streisand effect. And so you have the same thing play out here. Like many of my corporate adversaries, corporate America, big law, et cetera, who do this sort of thing, right? And this happens routinely. I think every week I get a letter where it's like, we have reason to suspect that you are talking on the internet about our company. And now we can't prove it, but we know it's about us, and we are really upset and mad, and we are going to sue you, right? Well, no, you're not. No, you're not. Like, please, by all means, go ahead, do that. Oh, my God. You want to talk about spectacle? You want to talk about spectacle? That would be the absolute most phenomenal spectacle in law, litigation, society, media, okay? Because it would draw attention to whatever I posted, the underlying post. And then it would draw attention to you and your company and the law firm. And it would all become a big, like, just public spectacle, three-ring circus. And let's map that out. One, I would be able to defend against it based on, let's say the fact that I never identified you. And then two, like, by virtue of you suing me and putting that into the public record, you would be identifying yourself. Isn't that brilliant? Isn't that brilliant? Isn't it almost as if, like, I baited you into doing this? Wow. Chess. You're playing checkers. I'm playing chess. Okay, like three-dimensional chess. But then you would out yourself by initiating such proceedings. And then you would get Rule 11, which is sanctioned for pursuing a frivolous lawsuit or taking a frivolous position in litigation. You would also have a litany of problems and defenses you couldn't overcome. I would have standing under the anti-SLAPP law, strategic lawsuit against public participation. You'd be clearly filing a SLAPP lawsuit, and I would have anti-SLAPP remedies. I would also have truth, because you know what's so funny? If you really want to escalate this with me, if you really want to go, okay, we can go litigate it, because I'm not a counterparty to any arbitration with you. We have to go to court. I get a jury trial and it's all public. And then I get to prove the original premise of whatever I said. So if I talked about like corporate corruption or shenanigans or people being incompetent, we get to go. And I get to put on a case where I say, one, it's opinion, and two, if it is fact, it's all true, okay? And then all the other defenses I have, rhetorical hyperbole, qualified privileges, et cetera. So back to the drawing board there, folks. I know that is the latest corporate bruiser Biff Tannen. It's the latest Biff Tannen. It's the latest Biff Tannen technique, right? To send me these cease and desist letters about my posts on LinkedIn where I don't even mention you by name and don't even provide the identifying details and tell me how you're going to sue me and govern myself accordingly, et cetera. But you lose. You lose. You stole fizzy lifting drinks. You lose. You get nothing. Good day, sir. Good day. See, one of us is having the time of our life doing this, and it's not you. Have a good one. Be easy.